difference. Okay? The only difference lies in the grounds of appeal, basically. Okay? The beauty with appeals, you repeat the same things, whether in civil and criminal. They have the similarities. Okay? There are so many. So if luck hits you well, you appreciate the appeals in criminal. Civil will be a walk. But as I told in our first class, that the biggest challenge we have is that our background matters. The work of term 1 and term 2, because it is very hard for you to peruse a record of proceedings, because it is in order, it is in a procedure form. You peruse from the charge sheet, you go to plea taking, you go to examination, you go to ruling on no case to answer, you go to the defense's case, then you go to final submissions, and then the judgment, and then the sentence. And that is the procedure. So if you didn't appreciate first term and second term, appeals are going to be hard for you. You will be unable to formulate a reasonable ground of appeal. And you know, we have what we call summary dismissal of an appeal. You know it. Did you read about it? Once court reads your notes of appeal or the memorandum, and they realize that you have useless grounds of appeal, it's summarily dismissed. But for you to have justifiable and reasonable grounds of appeal, you should be able to read that record. That record was only 44 pages. Now, what about the next workshop? What if you do a second appeal, which has an appeal already, and they give you an exam of 75 pages? Will you die? But how will you be able to encounter all such challenges? I told you, you will see the first paper of 2019-2020, we had 65 pages. 65, an exam, just a case of 5 pages. Versus Uganda up to now, you've not read it. Okay? So, big key. So how do we deal with appeals? I'm going to repeat almost the same so that we get to the workshop. First things first. I told you we summarize it into how many words? How many words? 5. The presumption is our first word of a complainant, we are okay with it. Then suspect, we are okay with it. Then accused. So what you should note that appeals, for you to understand appeals, you start from accused. That is the charge sheet. Okay? Then ask yourself, what are the rights of this accused person? A right to fair. What is inclusive of a fair trial? The right to take plea. We are dealing with an accused up to that time. Okay? This accused has a right to bail. So they will give you facts where this guy was not granted bail at the court of first instance when he has been on remand. It's not by mistake. Okay? In your workshop 1, you people, these guys don't do things by mistake. This guy was granted bail. Not so. All the trial, he was at home, coming from home, until he was convicted. Now you will find a legend who went for bail pending appeal. Why? Because you have Emma's notice. They knew in Emma's notice they had bail pending. They said, let us change something small. They brought extension of time. So you find a legend, you have to then offer Emma's notes up to the end without understanding the difference in this work. So whenever you are reading, understand. So once you see that my accused person was granted bail at the hearing here, just know I'm not applying for bail pending appeal, because she has exercised that right. Okay. That, and it's hard on appeal because it's not provided, but it's unconstitutional. Because bail is only available to who? Accused person who is presumed. Once you are convicted, are you still an accused person? So why do you go for bail? Don't you see the challenge? Okay, and that's what they want in workshop. You wait. Okay. Now we shall get there. Okay. So now we say now we know who an accused is. Then after this person being accused, he or she is going to be tried. So during the trial, a couple of things happen. Okay. And under that, that's how what we call adducing of evidence. So the presumption is you know all the laws and the principles regarding evidence. Because they'll give you a case when they have given you a particular set of evidence and the trial judge misdirected himself. So that means if you raise that ground of appeal, you're going to educate the trial judge as it was in your workshop. Okay? The trial judge misdirected himself on the law regarding single identifying witness. They didn't consider the factors in our prominent case, not so. So, for you to argue that ground, you had to be well grounded in that law. Yes? But the one who said he saw was only one, the dad. He said, I opened the window, which was a few meters that he mentioned. The boy said we never got out of the house. You get it? So the dad is going to open the window and saw. But they even don't know how they were dressed. Did they identify? So the judge misdirected. So all of that is, we are still dealing with the accused person. So after adducing evidence, and the court is well conversant with all the principles of the laws, and the prosecution has proved beyond reasonable, this person will become now a convict. Okay? Will become, that's our fourth person. You become a convict. Once you are convicted, court will pronounce itself, okay, on the conviction. So ask yourself, what are the different types of convictions we have? We have, okay, once you are convicted, a conviction comes with a sentence. So ask yourself, what should we consider in regards to convictions and sentences? We have a very clear law that provides how you should be sentenced. So when you are reading, now you are at this person who is now a convict. So ask yourself, what are the rights of a convict? That's why each and every judgment down has, you have a right to appeal. So the first right of a convict is right to apply to appeal. Okay? So once you want to exercise the right to appeal, now you become the last person known as the appellant. So that the appellant enjoys only one right, the right to apply for bail pending appeal. But that right has a lot of questions because a number of cases have criticized it. If you read the case of Ochepa versus Uganda, it's a 2020 case. It came out today, when tomorrow we are going for an exam. So it's only reading list. So Ochepa versus Uganda. It was an application for bail pending appeal. Okay? It changed the jurisprudence on bail pending appeal. Okay? Very. So Ochepa Geoffrey versus Uganda. Yeah.
Number 22.
Okay, number 22. So, you see, we used only 5, those words. So that's why I was always, every time we came for criminal, I was referring on those words for reasons. Because if you know how those words operate, criminal is the simplest. So now we are looking at our last word now, which is the fourth word was convict. Then right now you are dealing with the third. We have complainant, suspect, accused, convict, and appellant. So at this time we are dealing with the appellant. The entire third term is for the appellant. So you see, there are 5. You've covered how many? That means you've covered 85% of the coverage of LDC or immediate. Okay? You've covered 85%. Okay? That's how you mark yourself. Okay? So now, when we are dealing with appeals, okay, what things should we first put into consideration? How would we read to understand appeals? Okay? Whenever you are dealing with appeals, you shall get back to the workshop and the laws. Don't worry. Okay? Whenever you understand that I'm dealing with appeals, first ask yourself, what type of appeal am I dealing with? Okay? What type of appeal am I dealing with? We have a first appeal. So ask yourself, if I'm dealing with a first appeal, do you know all the categories of first appeals? Okay? So, first appeals. A first appeal is an appeal that arises from a decision of a court of first instance. So you ask yourself, what are the different categories of first appeals? And how do you get to know that I'm dealing with this category? Okay? Because reading this thing, I'm telling you, in an exam, you're going to this on Friday. It's not bad. You'll get out. And you're one code. None ground, solar vehicle. That volume. But Jakujiza, we're going to put a minute around 25. Okay? Okay? You can copy a ground of appeal, then add it and use. That's the challenge with this term. Okay? So now we have a first appeal from a chief magistrate court to the high court. Okay? These principles apply in criminal and civil. So many at the same time. That's why I'm not looking at the law right now. Okay. Yes, that's the first category. We have from chief magistrate to high court, where the matter was determined by the magistrate's court in its original jurisdictions. Okay. Determined by the magistrate's court in its original jurisdictions. Okay. Then we have another one. We have first appeal from the high court, the court of appeal. Okay. We have a first appeal from the high court to the court of appeal. Then we have a first appeal from which court?
Court of Appeal.
From the Constitutional Court to the Supreme Court. But yes, but we are referring to the Constitutional Court now. Okay, so now, whenever, how do you get to know that this is the kind of appeal I'm dealing with. So what you do, once they give you the workshop, even before all the exams, even before reading anything, open the judgment. In the first place, you open the judgment. You only go to the title, okay? You go to the title because you have to know how to do things very fast and understand. So what you do, you go to the judgment, look at the title, the Republic of Uganda. In the court they mentioned, that means it's the court of first. If they say in the Chief Magistrate's Court, get to know that I'm dealing with a first appeal from the Chief Magistrate Court there, you've started solving the problems. Okay, so now that means, remember the court where you are in determines the law you read, you know, so once you start the Chief Magistrate's Court, you just get that I'm reading which law? The MCA. So that means the rest of the acts taken by. Okay. Now after reading and you ask yourself, the High Court of, so that means you're dealing with the first appeal from the High Court to the Court of. So what you do, you get the TIA and the Court of Appeal rules. You know why? Matters in the Court of Appeal, they have a different procedure. We can't use the criminal procedure code. In the civil, we can't use the civil procedure rules because they are not applicable to the court of. Okay. Once you see that it has the constitutional court, that means you are dealing with the first appeal to the Supreme. So what do? You get to the Court of Appeal rules and the Supreme Court rules. So that you're looking forward. You read the MCA. Okay.
Criminal
procedure application rules. Simple as that. Yeah, that's mandatory everywhere. Okay. So now, that is our first, then our second type. So what we call second appeals. But when you are dealing with first appeals, just know first appeals are on matters of law and facts. Now, what if they ask you, guys, what? And so what? Comment from one ground of appeal. You know that every word in the ground of appeal has a reason, and under the law it is there. The reason why we say the trial magistrate, why? Which is the first appeal. On first appeals, we use the word trial magistrate or trial judge. On a first appeal, on a second appeal, we don't use trial because we have not been on. Mark those things. Okay, we use the appellant judge. Okay, you get it. Okay, we shall get them in appeals, don't worry. Then we say the trial magistrate add in law and fact. You know why? We appeal on matters of law, and that's why we say the trial magistrate add in law and fact. Because first appeals, we appeal on both matters of law and is that saying either on matters of facts? They should be both. They should be both because the law is we appeal on matters of law and fact on first appeals. That's why it's like that. Then after the trial judge has added in law and fact, what happened? He came to a wrong conclusion and later miscarriage of justice. That's why we say the trial judge add in fact and law when he put what he did, misdirected himself on the law regarding identification as occasioning a miscarriage of The reason why we have this word hence, it is because that's the reason why you are going to. If you got justice, why are you appealing? Okay, you should indicate the effect of that decision. The effect is miscarriage of. Okay, that's why the ground is framed in that way. Okay, then our second category. That is the second appeal. That's what it is. Okay, so now second.
You can appeal on factors. You can't appeal on ones.
Okay, you only, so when it comes to second appeals, we only appeal on matters of law. Only. Exactly. Yes. Okay. So second appeals are on matters of law. Now the difference is on how do you tell that this is a matter of law, this is a matter of fact.
Appeals against written.
Yes, that's why the right to appeal is a feature. That's the use. The law says it. That's how the law is. Okay. Yes, Kat. Yes, you don't have an automatic right. Okay, that's why your first issue should be whether so and so has a right to appeal. That's why it's limited by time. Not everyone can appeal. Okay, you will differentiate in civil when you didn't review, revision, and appeal. That's the day you'll understand you'll get out of the class. Well, an appeal over review. And you're lucky. Criminal has only two: revision and appeal, and they are so different. They're civil. You'll sit in the eye of a but with review. Or to neno ngakwa revision boy inapi. Yeah, I'm telling you people. Okay, but the gist is on just a few words. Okay, so let's go. In an exam, you get out, you ask your so the answer is you read and get to know how those indicators that always tell you that this is appeal, this is review, this is revision. That's why they have told you, please pay attention in that term. They will put in that auditorium in front there. They bring that. It happened to me. I personally, I left the library thinking that the auditorium is safe. My dear, I sat in front. Sat to sit as me. I make a decision that let me go for appeal or review or revision. Whether I die, but God was on my side. I went with the right answer. Okay? But if I'm telling you those things, we shall get to know them. Okay? So let's look at second appeals. Okay? So the second appeal, we have, okay, to say it is only on matters of law. So when you are formulating a ground of appeal on second appeals, we say, yes? How do you what? We are going to go there, okay? So now, once they give you the workshop or the question, you again open our judgment. Did you always have up here, okay? Civil appeal number or criminal appeal number arranging row. Once you see that, just now dealing with the second, so just look at the court where it was. If it was civil appeal number this in the High Court of Just no, it was a faster, it was an appeal emanating from the decision of the Chief Magistrate's Court. Okay, that's how you're gonna do. Okay, I'm dealing with, and once you see the volume of the papers, you just get to know that I'm done, because it is going to have proceedings from Court of First Instance, proceedings of the First Appellant Court. Okay, so that means you have to read with a sober mind. Don't panic. Okay, so that's how second appeal is tricky. It has a lot of work, but getting out the gist is the problem. Okay, but we shall get there. Don't worry. Okay, so you see, we are still being only one person, the appealant. Okay, so now, when you are formulating that ground, we don't use the trial. Why? We are past the actual trial. We are now on the, it was an appeal. So we can't say the trial judge, because this wasn't the court of first, it was an appeal. So we shall say the appealant judge, not the appealant trial judge. You always see those things. Okay, we said the appealant judge add in law. Add. Okay. Okay. Yes. Okay. When misdirected himself on the law regarding identification. Why? We have the law, not so. We have the law that stipulates how, okay, we should deal with identification. That is a matter of law. Okay, simple as that. And by the time second appeals, you always get like 2 grounds or even 1. But first appeals, you can even get 6. You saw how many you had. The least firm had 4, I'm very sure. Okay, but the maximum was 6. The maximum was 6 because you had an issue of general evidence, identification. Some PAs were telling you to divide the issue of a sentence, illegal and harshness. Okay, I know. Okay, that is harshness. So how to break it and show how it's harsh. It was irregular. Okay, so together. Okay, so now what are the categories of second appeals? We have a second appeal emanating from the High Court in exercise of its appellate jurisdictions to the Court of Appeal. Instead of saying that, that's what I'm saying. That an appeal emanating from the decision of the High Court in exercise of its appellate jurisdictions. So we want me to say that an appeal emanating from the decision of the High Court, which was appealed against the decision of okay, so we said the first category we have is a second appeal from a decision of the High Court in exercise of its appellate jurisdictions. Okay. Now, there is a challenge. It was in the case of is it KCC, Elias Lukwago versus KCC on appeal. Remember that saga? Because the Court of Appeal has a challenge. We have what we call the full bench. Okay? And then single member bench. So we have decisions where an appeal was determined by a single justice of Court of Appeal. Do you appeal to the Supreme Court or you appeal to full bench?
We appeal to full bench. Actually, only remember when let's say,
Okay.
Justice and the Deputy Justice by then.
But
When he issued that order, and then it became police for the throat and power.
okay, so we have that appeal. That one is tricky, but it happens in civil. So where the court of you had a matter emanating from the High Court in excess of its original jurisdictions, and you appealed to the Court of Appeal, and the matter was determined by a single justice of Court of Appeal, and you are not satisfied, you don't appeal to the Supreme, you appeal to the Court of Appeal to full bench of review. It's a second appeal, but in the same. That is cases to go back.
It was an application.
Yeah.
When he went for the then he rushed back to say, I want to go back.
He went to Supreme Court first, and he was referred back.
Yes.
That
Then
he
also
go back.
in the whole time, I will not pass the judgment.
So, mark that. Those will come in civil. So it's also the second category of a second appeal. So it is an appeal emanating from a decision of Court of Appeal presided over by a single justice to full bench of review. Okay.
High Court and exercising its pastoral jurisdiction.
It is okay. You had a matter in the High Court in its original jurisdiction. You made an appeal to the Court of Appeal, and it was done by a single judge. Then also, at the satisfied, you want to go for a second appeal. So the second appeal will be to the full bench of review. Okay. Perception. Okay. So then another category is an appeal emanating from a Court of Appeal in exercise of its appellant jurisdictions to the Supreme Court. To the Supreme Court. And the Supreme Court is the final appellate court. But note, a second appeal by, do you have, is it automatic or it's upon leave? Okay, and so when we get to civil, it's the hardest type of appeal because not everything is appealable in civil. They don't appeal on everything in civil. 90% you have to seek leave. We shall sort that when we get there. Okay, so now, yes, we have what we call third appeal. Okay, we shall deal with that in civil, but I'm just explaining. Okay, so now we have third appeals. Under what circumstances can we go for third appeals? Huh? Okay. Third appeals are only allowed where a matter is of great public importance. And it should be put, and the court has to first give you leave that yes, this is a matter of great public. Not all matters are of great public importance. It is a second appeal. Yes, it's a second appeal. Yes. That's a second appeal. Now, okay. Okay, I will get. So third appeals are only on matters of great public interest. Not everything is of great public importance. The court has to first grant you, give you a certificate that indicates that this is a matter of great public, okay, where you are going to appeal, okay. But in most cases, such matters are matters that emanate from which court?
Constitutional court.
Eh?
Constitutional.
Court of
You can constitutional court, court of appeal, Supreme Court. Aren't they three?
No. It's constitutional.
Okay, in most cases, they happen where they are determined one by a single judge. It was a matter of high court, then it went to court of appeal, and it was determined by a single justice. That's the first appeal. Then you appeal to the bench of three, okay? Then that means it's a second. So to go for a third appeal to the Supreme Court, it should be a matter of great public importance. You get it? It's rare. It's rare. I've never even seen it. It's rare. You have to go for a third appeal. It used to happen where we had which type of magistrate courts? When you had grade
2.
So you could have grade 2, then you appeal to chief, that's 1, then you appeal to high court. Then you had court of, which was a third. But ever since it was quashed, those appeals are rare. Okay, but just for purposes of consumption. So now, let's get our workshop now. Let's get the laws. Okay, let's get our laws. Okay, let's get our laws. Let's get our workshop too now. We are going to follow the same procedure. Okay, someone with workshop 2. This workshop was amended. Hope you are aware. Okay. I'll show you. Yeah, it was, they sent instruction. Yeah, yes. Yes.
Yeah, they said they would amend the country, but we didn't.
I saw an email which says that for workshop 2, consider it to be the magistrate, chief magistrate's court. Did you see that amendment? Okay. So now, presume that this workshop is in the chief magistrate court attached to the anti-corruption unit. Okay. Are we together?
Yes.
Okay. So now, I'm sure people in the discussion group, they did see this email, and they proceed most of them using high code. That's why I told you, whenever you read the right law, first go to the judgment before you do anything. Okay. So, because the offenses herein are tried by the magistrates court, they are not offenses of the high, so it could cause an upset. That's why it was amended. Okay. So now let's get our workshops. Okay. Are we all there? Members who are online. Okay. Okay. So let's go on. Are we all there? So whenever, before you do anything, as I've told you, for you to be able to deal with appeals, you first get your judgment. Okay? You first get your judgment. You look at the heading. Okay. So the heading says the Republic of Uganda in the Chief Magistrates Court of Uganda held at Kampala Anti-Corruption Division. Okay. So what does this mean? It is a first appeal from the Chief Magistrates Court. So even before now you do anything else, okay, you write issue 1, okay, 26, okay, so you write issue 1, okay. This work, it's a workshop you can do in 50 minutes when you're done. You're going to see, okay, yes, 50 minutes when you're done with the workshop. Okay, so after reading this, you realize that it's emanating from the Chief Magistrates Court. So the presumption is you read the instructions, you know the person you are representing. Okay, so now you write your issue 1. You ask yourself whether your client has a right to appeal. Your client has a right to. We've said an appeal is a creature of statute. Then you get to ask yourself which statute. We've seen it is Chief Magistrates Court, not so. This matter is criminal. So you get to act the Criminal Procedure Code Act and then the MCA. Okay? So now, so you first go to the law that provides for appeals in the MCA. Okay? First, because you want to see whether he is among the persons who can appeal. Okay? It is section 204. Let's read it. Someone with a portable app. Portable like me. If you forget up, I'm telling you. Okay? It says, okay. When you are reading this act, people have issues with reading the law. This act says, okay, the section says, yes, okay, subject, okay. It says, subject to any other written law. You underline the word subject to any other written. So which law are they referring to? The Criminal Procedure Code. So that means you're going to put into consideration the section on appeal, okay? Because this section gives you a right to appeal, but subject to the conditions set out in some other law. We go on, okay? Subject to any other written law, except as provided in this section, an appeal shall lie A, to the High Court by a person convicted. So the first thing, ask yourself, okay, by a person, is your client convicted? Yes. You tick, okay? He falls under the category. On a trial by a court, so ask yourself, was there a trial? Mark this, was there a trial? Under what circumstances will trial not be available? Yes, under what circumstances will the trial not be available? So where you plead, so that means whenever they give you the workshop and you seek plea of guilt, there wasn't trial. Okay. Okay. We shall go there. Don't worry. We shall solve it. We proceed. Okay. Then it says, it goes ahead and says that by a court presided over by a chief magistrate, a magistrate grade 1. So you open the judgment. You have now at the back, okay, it is presided over by which magistrate? It was by a chief. So that means your client passes the first bar. Okay, grade 1 or
Chief.
now you see the chat, they made some few changes. Okay, workshop 1, it was presided over by grade. Workshop 2 by, we go on. Okay, so now we are not interested in B. Okay, then you go to 2. Says that an appeal under subsection 1 may be on matters of fact as well as on matters of law. That one will resolve of this, not so. Then you go to subsection 3. Okay, it says no appeal shall be allowed in case any person who has pleaded guilty and has been convicted on that plea by the magistrate's court, except as to the legality of the plea or to the extent of legality of the sentence. What does this mean? Section 204, subsection 3. This means that once you plead guilty, you don't appeal against the conviction. Okay? You don't appeal against. So we don't expect you to have a ground on appeal on evidence that the trial magistrate had in fact and law when he failed to evaluate the evidence. Which evidence? Okay. That is plea of not guilty. Okay. So you get it. Once you read and see plea of guilty, there wasn't trial. So that means you don't follow, you follow under different what you are. Okay, what you are. Okay. Yes, you only appeal against the sentence and plea. What does that mean? You only have 2 grounds. Only 2. Plea and then the sentence that it is harsh and irregular. Okay, you appeal against the procedure of plea taking and the sentence that it was harsh or irregular. You don't appeal against the conviction.
So you just said you lose the right to appeal on the conviction.
Yes.
No.
Okay, so you get it. So when you are resolving issue 1, whether your client has a right to appeal, these are the things you look at first. Then the last thing you look at is under subsection 4, which says that no appeal shall be allowed in any case where the court presided over by the chief magistrate court or grade 1 has passed a sentence of imprisonment not exceeding one month only, or a fine not exceeding 100. But this one is rare in practice. Okay, it will be amended anytime now. Okay, so you get it. So they will give you where the guy was given community service for 1 month. Bakugamba ayagala appeal. Kwata kiraba anti revision. Okay. Now, okay, let me tell you this. Whenever you change the workshop and you see that the client has no right to appeal, the answer is these are things we look at. Okay? Our losing right to appeal against a conviction. Okay, no someone free for lying and katinga sentence ye court. Ninga holaba. Katiba kuwe sentence ngali out of time. To take Roger na appeal. Okay, nga ziwedde jo. Ogambe ogambe awo. Your head will work. You either say, let me decide at once. I go for revision. They revise the sentence only because it's allowed. Okay? No, I don't see an error apparent in the case of. Let me go for. Let me first make an application. Extension of time. Then I go for appeal. Now, over where you see how you are extending the exam. You won't finish. Okay, that's how the final paper can mean to look simple, but tricky. Once you are done good enough at all this, they will see they make a marking guide for revision and appeal. Yes, that's what they do. They are good people. They know that we shall have legends who will go for an appeal with the extension of time. They say we have these ones who will go for revision. So they have two marking guides. Application, the extension of time. Okay. Okay, so you get it. But if I do revision, what if an application for extension of time is not granted?
How do we Can you ask for revision and also appeal, or you can have it?
You have one. Okay. Yes. So we go on. Okay. So now, and after reading this, okay, ask yourself, which other ground do we look at ascertain whether our client has a right? When we are starting this section, it starts with subject to any other written law. Now you come back to the Criminal Procedure Code Act. Okay. Section 28. It says I want you to listen. It says every appeal doesn't matter whether it is an appeal to the High Court, to the Chief Court, to the Court of. Okay, mark that. Okay, it says every appeal. We don't provide the criminal appeal. It's supposed to be lodged within how many days? 14 days. So the first category, your client has passed the test. Now you come to the second test of time, whether your client is still within. So after reading this, don't waste time. Come and open the judgment at the end. Okay, at the end, look at the day when the judgment was delivered. Okay. Yeah. When was it delivered?
15th May 2023.
So you count the days. Your client is still within. Now you see the distinction between workshop 1 and workshop 2.
Yes.
Now, workshop 2 I know it is going to have bail pending appeal. Because if I looked at the proceedings, your client was not on bail. Not so? Yeah. Your client was not on bail. In the first workshop, the guy was on bail throughout. Okay. So let's go on. Okay. So section 28 says 28 is very clear, within 14 days. So after counting the days, okay. What is this? Okay. After counting the days, and you are still within 14 days, then you come to the conclusion that your client has a right. So where you count that client is out of time, the conclusion is your client has no right. So each one will be resolved. Like very simple. Okay. So now, what happens when your client is out of time? We have the answer in workshop. Cancel for the week. So you're making an application for leave to extension of time. Okay, that's the mode. Section 31, very clear, short and precise. Okay.
31.
So section 31 of the Criminal Procedure Code Act cures that, together with which section?
Rule 2 of the
Rule 2 of the
Criminal Procedure Application.
And then section 16 of the Judicature Act. Okay, so where you are out of time, once you realize that out of time, your second issue will be what interim remedies available. Okay, so you answer that immediately, that the remedy available is an application for extension of time to lodge a not so appeal. You go to section 16 of the Judicature Act, you come to section 31 of the Criminal Procedure Code Act. Okay, 16 Unification Act. Okay, and then that has marks of 1. Then rule 2 of the Criminal Procedure Application Rules. That's why the application is by note. So I saw people. I looked at some pleadings. It had no applicable. Hey, and mark this. In that application, we don't include grounds of appeal. I saw some content which in the notes of motion, it had grounds of appeal. It's like, you just attach a proposed memorandum of appeal for the notes of appeal. You said that the applicant has a justifiable and triable appeal or justifiable and reasonable grounds of appeal. See attached a copy of the proposed memorandum or notes of appeal. Okay, but you wait tomorrow. See attached. Okay, a copy of the proposed memorandum or notes of, because some notices of appeal they include grounds of appeal. Not so. Okay. But if you've not heard of it today, that's the end of it, because they don't repeat it. Yes? Okay. Yes? No, you just said that the applicant has justifiable and triable grounds of appeal. Attached is a copy of the memorandum of appeal. So you go, you draft the memorandum, you attach it. Okay, so counsel for the week, mark that, yeah? Justifiable and reasonable grounds of appeal. Okay?
Justifiable and reasonable.
Tribal. Okay? So now, the presumption is your client has a right of appeal now. Okay? You attach the memorandum of appeal or not of appeal, which has the grounds, because it's just proposed, but if it's not that ground, or the drafting. Hey, you ask counsel for a week what I do. And what was it? But how are you going to prove that you have a justifiable ground of appeal? You take a court or in Annex B. The Annex you have 1 is the judgment, and Annex 2 is a memorandum or not so. Okay. Record Vatican reason again a call for appeal. Okay, so you don't attach it. So let's go. So now
you can put a notice of appeal, right? When you put a notice of appeal, you're supposed to file it together with the record of appeal. So you can only ask for it by letter. You can attach a letter and then start counting 14 days after.
At where you don't have it, but they gave you the record for reasons. They gave you the record already on the workshop, yeah, for reasons to avoid such issues. Okay, so now you have a right to appeal. So how many issues do you have? So you go to the third issue. It says, okay, the first issue was whether our client has a right. So if we realize that our client has no right of appeal, we get our second issue, okay, which will be what are the interim remedies. Then you discuss application for extension of time. That one is sorted. Now, this is what we call the mega issue, the third one. Okay. What are the merits? Okay. Or what are the grounds of appeal? What are the grounds of appeal? But what others do, they said issue 1. Okay, what is the substantive remedy? Now appeal. n'asirika n'akomaawo n'agamba section 204 n'akomaawo n'agenda ku issue, and that's how you should answer the exam. Okay, briefly n'agenda ku issue 2. Okay, whether he has the right to appeal. 5 lines n'agenda ku issue 3. What are the grounds of appeal? That's listing issue 4. Like that. You don't waste time. Okay, so let's see how we get the grounds of appeal. Okay, now if you want to have good grounds of appeal, you see this record, they'll give an exam very well. And now make matters worse, an exam available on a police file with this. Remember, number 1 is your term 1 work in a criminal. That's its standard. Okay, they choose any good offense that is so confusing. Yes, you already have a police file. You saw police files. You have six statements. Okay, you have the charge sheet. You have annexed years. That's number 1. Then they also give you this. So you go with your booklet as the exam papers, and I am. So you have to read for number 1. You shift your mind to number 2. Now you ask yourself, how do we summarize this? Okay, so what happens? You know your criminal procedure. Okay, the first thing you look at is the charge sheet. Okay, when you are reading this record, you just come to the charge sheet. Why? What if court proceeded on a defective charge sheet?
What would be the interim remedy?
Workshop. I wasn't trying to expel me. Shall get it. But you have to first file an appeal, get it. Okay, that's why it's mandatory. Okay, you get it. Okay, why? So let's go to our charge sheet. What if you have a charge? How do you tell that the charge sheet is defective? There was a question on your charge sheet on workshop 2. Not so that it was not consented to. Does it make it effective? Is it fatal or not? Is it mandatory to consent to charges? Is it mandatory? Okay, we have charges where it is mandatory. Okay, so which law provides for that mandatory requirement? Which word does it use? By who? No, that's what I'm. No, you get the act of we don't study by hearsay. I show you your act. Where's your act? Cancel for that. Where's your act? You finished orals. Okay. So now we have of workshop 2. So these are the following things that you look for. 1, look at the statement of why. No. Statement of a section which does not rhyme with the offense. So you think these guys are just, these are not everyday people. They are advocates who set these papers. And with experience, they know you people don't want to read simple things. You don't pay attention to details. So what if they give you, because what you said, section 204 of the Penal Code Act, they give you corruption. So when you rush, so do you have corruption in the penal code?
No.
So they will give you a wrong section. That means the principle of legality has not been followed. So that means the charge sheet is effective. So once you get it, look at the statement, go to the law, get the penal code, get the anti-corruption, any act where that offense comes from. Go to the section and you first ascertain whether the offense and the punishment are prescribed under that law they are saying. Because it's the duty of the court to amend the charge sheet, not so? Yes. So how could court proceed on a defective? So once you realize that that mistake is there, it is a ground of appeal. If not, where it is a law where the offense emanates from and that offense is mandatory to be consented to, and the charge sheet was not consented to, does that make it effective or not? Okay. So, did the trial magistrate add in law and fact when he proceeded on a defective charge sheet? Yes, it was not consented to that charge sheet. Those are the some circumstances that are called merits. Once they say merits and merits, they want you to first question the grounds and support them with their merits. Then you oppose them that they merits. And once you get that question in the exam, just sit it. Because you will write and write and write until you get out of the exam, not only not done. That's negative. Okay? Because you can't try the grounds of appeal and you oppose them, not scarango chatting. Okay? So now, our charge sheet has an issue. Okay? It was not consented to. You see it? It's blank. Okay? It is blank. Okay? They don't do things by mistake. Okay? They don't do things by mistake. Okay? So that's one ground. Okay? So now, after this person has been charged, is how we call it? An accused person. So once you are accused and the charge has been laid to you, you have to go for plea taking. Then after reading the charge sheet and realize it is defective, you get a ground that the trial magistrate had in law and fact when he proceeded on a defective charge sheet, hence occasion in the miscarriage of justice. Okay, that's one. So then let's go to our plea taking. Once you go to plea taking, the presumption is it's called Adan. So the presumption is Adan is in your head. Okay, so once you are reading this, okay, once you are reading this, you recall your Adan verses. So this step was missed. I don't think. Okay, so now let's go to plea taking. Okay, state the matter is for plea accused. My lawyer is on the way. However, I am comfortable with taking plea in his absence. I understand English. Quote, plea taking. Charge given to the accused in English, which he understands. Count one. He understood. Okay. PNG entered. Plea of not guilty. Okay. Plea of not guilty. Okay. Then count two. He has understood the same thing. Okay. So now, is this procedure right? Is the procedure right? What is missing?
Reading the charge,
The charge sheet was read. Once a plea of not guilty is entered, does court inform this person his rights or not? Read Adan versus Republic. Look at this procedure. The court just said PNG entered. The matter is fixed for that. Okay. Okay. The case is fixed for 16th and 17th March for hearing starting at 9. Extending bail for the accused till 16th. That means the accused was granted bail. Yes? The accused was granted bail. Okay? Extending bail. I want you to read that. No, there is a problem on this. Okay? At what point do they apply for bail? At what point do they apply for bail? After plea. Look at the wording, extending. So this guy gets bail before taking. You see, there is a problem somewhere. Okay? You see, there is a problem there. They are not, it's not by mistake that they're using the word extending. What does that mean? They are just, he was already on. So before taking the plea, this is magistrate court. You can apply all that.
Yes, sir.
What did I do? Yes. Yes. Self-represented. But they are using the word extended. That means this guy was on bail even before taking plea. Is that the right procedure? You put a star. Whenever you say problem, there is a problem still. Is that the right procedure of plea taking? Okay. After entering a PNG, okay, court had to say plea of not guilty entered. You have a right to apply for bail. Okay, and then court will proceed if you apply or you don't. But now, instead of telling you, they just extended bail. So did the court take the right procedure of plea taking? Okay. So we said the trial magistrate had in law and fact when he adopted a wrong procedure of plea taking, hence occasioning a miscarriage of justice. Okay. The trial magistrate had in law and fact when he adopted a wrong procedure of plea taking. Look at the wording you use. The reason why we say adopted, but it's there in the law. Okay. Now, after plea taking, this person took a plea of not guilty. What's the next step in criminal procedure? Except it is, that one is done. After plea taking, what is the procedure where a plea of not guilty is entered? Prosecution is. So we are going now to read the prosecution is case. That's what we call examination. So now, mark this. In examination, you always have basically two issues. We have a general issue on evidence. Once you read a few lines and you see contradictions, you formulate your first ground that the trial judge had in law and fact when he failed to evaluate the evidence on record. Hence coming to a wrong decision, occasioning a miscarriage of. So the reason why we read examination, we are looking basically for three things. One, contradictions. Okay. Now you see who? Now it depends. The challenge we have different PAs, not so. Yes, sir. Mm. Okay. So you first read. Once you see contradictions, we have a principle of law. Not so? Can court based on evidence full of contradictions? If you realize that court based on that, that's an error. Okay? You get your other ground. Then after that, you proceed. Look at the nature of evidence. Okay? That these guys had. Was it single identifying witness? Was it documentary evidence? Was it primary or secondary? Okay, what is the principle in regards to secondary evidence? What is the principle in regards to on admissions? What's the principle? You get it. So depending on the evidence they are used. So that means once you read the type of evidence in there, or you know it from A up to Z. Because if you don't know the law regarding admissions, confessions, extrajudicial statements, whatever the case may be, how would you tell that there is an error? Because for you will say that it is okay when it is not okay, because you don't know. That's the challenge with this part, that you either know or you don't know. That's the challenge with grounds from evaluation of evidence. That's the biggest challenge we have. So it is a very big challenge for you to get to know the right. So you either know evidence law or you miss out these two grounds. That's the challenge. So when you are reading here, it is very prudent. So the third thing we look for, a defense raised by the accused. Remember, once the accused raises a defense, as it was in your workshop 1, they can raise the defense of alibi. Court has to first pronounce itself on that defense. So they'll give you facts where court disregarded. So it is also ground of. Those are the three things we look for in examination. So when you are reading your examination, make sure, 1, you're looking for contradictions. Once you see contradictions, courts do not convict on contradictions. That evidence should be corroborated. Okay? Then the second thing, looking at the nature of evidence adduced. What is the principle of law in regards to that type of evidence? Did court apply the principle or it did not apply it? Adduced. Okay? Is it expert opinion? Okay? Is it hearsay evidence? What is the law regarding hearsay? And what are the exceptions to hearsay? Because when they're giving you these workshops, they know where you don't read. They will give you it was a dying declaration, but it wasn't relied upon because it is here. Is a hidden exception. So that means the trial magistrate adding facts and law when he misdirected himself on the law regarding hearsay evidence. Okay? So that means omani hearsay ogenda kumusomesa atadde mu line. But that means if you don't know, go kulaba as it is right. That's the challenge with this. Okay? So you see how first time is affecting you greatly. I kept on telling people, read evidence, read evidence. Okay? I don't know. Okay? So now, the third one is a defense. Okay? We have defenses of alibi. We have defenses of mistake. We have defenses of intoxication. We have defenses of disease of mind. So what's that? Because now the people facts where there is a defense of disease of mind. You don't know that under such circumstances, court has to conduct what? A trial within a trial. You ascertain your mental status. The time when you committed the offense, they will disregard you. or you proceed. Okay? And how will you cure that? Even Article 126 you can't cure that. Okay? It is a grave technicality. Okay? Yes. So now, you see the gap you have. Evidence. Okay? Evidence has issues. Okay? So now, how do we, after reading examination, okay, you skip submissions. That's the technique. We don't read submissions because they are irrelevant. We don't read submissions. Yes. Okay. Remember, we have submissions and no case to answer. They are irrelevant. You just go to the ruling. Once you read the ruling, determines the defense's case. Not so. The defense is going to be exactly the same almost with, okay, the prosecution's case. You don't waste a lot of time. Okay. What you do, you just go to the judgment. Okay. Yes. Okay. Judgment. What do we need in the judgment? In the judgment, leave the background. Don't waste time. Okay. Leave analysis of submissions. Just go to analysis of evidence, where the judge says that during examination, once you see that, just know that is analysis of the examination you read. So why are you reading this? You want to see, because you saw contradictions in the examination, not so? So you want to see whether, when the judge was analyzing, came to a conclusion basing on the evidence which has problems. You get it? Okay? Like in your workshop. Here now, when you are reading, you just come here to the judgment. Okay? Okay? You just come here, you start where there is count 1. All of this side, you leave everything. Okay? Yes? Okay? When you look at 34, that's where analysis was made. Yeah? Okay? That's where analysis was made. So you look at it and see how, okay, how did court come to that conclusion? What evidence did they use? Is it the evidence that has contradictions? Okay, is it the evidence of poor identification? Is it the evidence where the defense was raised and they're considering the same? You get it? Because you can't come to the, how do you tell that the judge adding law? After reading his reasoning. So that's, you just go on the reasoning of the judge. But for you, you think you're going to read the entire judgment of the Republic of Uganda, you doze in an exam. Okay, and you will not make it. Why do you read the background? You read the charge sheet, you know everything. Not so? Why do you read submissions of counsel? When that was it as they're irrelevant. Okay, just go to analysis of evidence, because you read the examination, you saw contradictions, you saw the defense that was raised. So the question you want to answer: did the judge deal with the right principles of the law when dealing with this evidence or not? That's what you're looking for. Okay, so once you realize that they are not dealt with rightly, then you formulate the ground of appeal. Okay, so in most cases under this we have 3 grounds. Okay, the first one, if you have contradictions, we say that the trial magistrate adds in fact and law when based on evidence full of contradictions. Okay, the trial magistrate add in law and fact when he convicted basing on evidence full of contradictions. Okay? Full of contradictions. So you'll just come here, okay, because we did workshop 1. You have to practice to get these two grounds from this. Okay, I'm going to get you the ones in the sentence. Okay, I got you the ones in the chart sheet and the procedure. So I have to leave these, the twat list. Let's start. The letter change to a plea of guilt. Yeah. They sent amendment here. Okay. So once he changes the plea, again everything. But again, once he changes the plea, you go back to the procedure of plea taking. Why? You look at the procedure of recording a plea of guilt again. Okay, that procedure is different from the one of recording a plea of not guilty, because here, after entering the plea, the state has to restate the facts. Then they ask you how you have appreciated them. You either amend or you agree. Once you agree, then they enter a plea of, okay? And now, once they give you that, expect it has to reflect in the sentence. Okay? That shows what we call remorsefulness. Okay? Remorsefulness. It is a ground of reducing your sentence. But now you will go back, you look at the sentence. Okay? You get it? So that means they put that to create room for ground of appeal in the sentence. Okay? So now that means the procedure of plea taking has no problem. Okay, if we change the plea, you get it. So the procedure of plea has no problem. So you put a stone that ground. Okay, so that means even whatever you've been reading in examination is useless. You get it? Before judgments, you have a right to change the plea at any time before judgment. So he changed after the examination afterward. Okay. After examination, he realized okay. So then after, now that means in workshop 2, you usually have like, so that means in workshop 2, we have a right to appeal, but only on a sentence and plea taking. But our plea has no problem. So you're only going to deal with the sentence. Very simple. So what you do, you open the sentence. Have you started? They have no. Okay. Only. Yes, the defective charge sheet and the sentence. So yes, no, you leave it there, but you pleaded. This guiltiness changes everything. Okay. That's why I don't have
how to understand the reading.
Yes, it's okay. Now, okay, we presume he didn't change the plea. Okay, okay, yes, I'm just, if this person didn't change the plea, after reading everything, you read the judgment, you'll be left with only the sentence. Okay, so now here, he changed his plea. So now, you just open the sentence. Once you open the sentence, covers all these laws, you go to what we call the constitutional sentencing guidelines. That means your answer lies there. Okay? Yes? You have them. Someone with the sentencing guidelines. Now, in workshop 1, there was
Rashid,
okay. The day they
Rashid.
convict you is not the day they sentence you.
Rashid,
Yes, Council.
those sentencing guidelines are unconstitutional. Even Wakabara said, why am I tried quoting them today, and she was like, why am I referring to them?
But
This is
now
the-
the challenge is, yes, that case nullified them, okay? But the challenge we have, they have not yet amended. So what should we do?
What was the previous law before the guideline?
Yes,
What was the previous law before the guideline?
okay. We had,
That's where we
I think-
default.
because these guidelines, they have what we call a practice direction, but it is also not inclusive. So what do you go for?
Okay, are you going to sit there and don't answer? Okay, which case nullified the constitutional guidelines? Yes, which case? Okay, it's on the reading list, not so. So that's the case you should read. Okay. Which case nullified the constitutional guidelines? But some PAs have not considered that position. If you realize, not so. Yes. The reason is, okay, the reason is, yes, court pronounced it so, okay, on the non-constitutionality, but no law has yet been made. So for purposes of consumption, you have to read.
Rashid,
Yes, Councillor.
the case is Mohamud and others versus Attorney General.
Okay, I saw that case on your reading list. Okay, Mohammed and others versus AG. Okay, so now how do you deal with the sentence? How do you deal with a sentence? Now, because of the challenge of these constitutional guidelines on their constitutionality, okay, but it's a case-to-case basis, okay, depending on the PA you are dealing with, okay, because this is a learning process, they want you to learn. Others are so strict because they're preparing you for practice. But for purposes of learning, they may want you to refer to the law so that you learn how it is read. But they always question you about its existence, not so? Yes, so how is this done? When you are formulating the ground of appeal, okay, instead of saying that the trial magistrate had in law and fact, when he sentenced the appellant to an irregular, you see irregular, you see the word irregular, because of these rules being unconstitutional, you leave it out. Okay, you leave it out. You say the trial magistrate had in law and fact when he sentenced the appellant to a harsh sentence, hence occasioning a miscarriage of justice. Okay, why? Because when you look at the word irregularity, something becomes irregular where the procedure set out in the law has not been followed. Okay, but harshness, okay, harshness comes from the principles of equity. Not so. So remember equity, these are laws applicable. Okay. Yeah, okay, but the way that he applied them is not right. Why? So as we go by this and the sentencing guidelines, the first thing you do, you go to guideline 6 when you are reading.
because it first provides the general factors all judicial officers should put into consideration when sentencing in the first place. Okay? It provides for the general factors for all judicial officers to consider when they are sentencing. Okay? And these include one, the antecedents of the convict. Okay? Is he a family person? Is he the solo breadwinner? Okay? Then also, they look at the mitigating factors. This guy gave his mitigating factors. Were they put into consideration? Okay? You see, because the law is very clear, then was this person on bail? Was his bail cancelled at any time? Okay, so that means he has never been on remand. So the time spent on remand is out, not so. But where you get facts, yes, he was in prison. So that time should be counted when they are sentencing him for a custodial sentence. It should be deducted, okay, and put aside. That's the procedure. That's how the section 6 says. Okay. So when you are reading your sentence, those are things you're looking out for. Then we have a challenge. We have a case of Justice Miller. I'm forgetting the parties, which talks about the plea. The plea. Okay. The plea. That where the accused person takes a plea of guilt 3/4 of. Yes. It is a decision by Justice, but I'm forgetting the names. I will share it with you if I come up. Okay. 3/4 of the sentence. Yes. And in that case, it has the same facts. Why? This guy changed his plea, okay, after examination. And then when counsel was mitigating, cited that principle, and Justice Miller overturned it and said it was just an afterthought. So it doesn't enjoy the right of the 3/4. And that's the basis counsel based on to appeal. That's why it is in this. I'm sure that case, I'm going to, I'll check my work. It's on the reading list. Okay? Because in that case, Justice Miller said that where the accused person takes a plea of guilt at the earliest stage, he has saved court's time, resources, okay, and it shows an excellent code of remorsefulness. But a person who changes his plea, it's always an afterthought, after analyzing that he or she has a bad case. So therefore, it doesn't enjoy that right of reduction. Okay, so look at your facts. Are you going to say that that sentence is harsh or irregular? Now that's the challenge where I think where the battle is going to be. Okay. So now, once you go to the last ground of a sentence, you've covered the entire thing. Okay. The last ground, you'll find the legend in the associate. No, it's the first ground. That oh, I say so. This person made the record from the bottom. That means no one to get. That's the technique as well. Hey, no, okay. Just look at the next one. Okay, that is it. Okay, so now after you formulated your grounds of appeal, you ask yourself, what does my client want? Okay, so at that point, you go for what we call, you go for the next issue. What is the forum of lodging this appeal? The law will always tell you. You see how we classified our appeals? Once you are coming from the chief magistrate, that means allowing the appeal where? To the High Court. the forum will be sorted. Then you go to what are the necessary documents. We know the law, section 28, that one is sorted. Okay, but then after lodging your appeal, we have another remedy. You ask yourself, what interim remedy is available in the circumstances upon lodging the appeal? That's when you go for an application for bail pending. You can't apply for bail pending the appeal before lodging because the grounds units of motion that the applicant has not an appeal in this honorable court, which has higher chances of success, that there is a likelihood of pay in determining an appeal. Okay, now we are just doing it general. Okay, but now because of the fact that this guy is convicted on his own plea of guilt, you don't go for bail pending. Now, who said that in workshop one you have bail pending? Now you've seen how it ends. Okay, and they gave you both workshops. When these guys were on bail in the first place, they would exercise the right. Okay. But please read the case of Ochepa versus Uganda. Read that case. Ochepa, Geoffrey versus Uganda. Please. The cases I want you to read before the week ends. Read that case of Ochepa. Okay. It will answer all your problems on bail pending appeal. Okay. Read it because it discusses the constitutionality. It breaks down Article 28 and Article 23. Okay, because those are the laws that provide for bail, but they have an accused person. This person is no longer accused. So the Constitution does not provide for. So that's why people are questioning the constitutionality of the Court of Appeal rules. Because the Court of Appeal rules, they have application for bail pending. So that means they are independent and not attached to the Constitution. So their constitutionality is also having a question mark because of that. Yes, Council. Now, because this workshop, they might be amending two ways. They might be receiving emails, keeping changing, because it already had a mistake. At the end, it was before a chief magistrate. Then the heading had High Court. That was the first mistake. And they corrected it. Okay. So that means this person has not been granted bail pending appeal. So now that means the substantive remedy is an appeal. That's what, yeah. They will amend. They will amend. Okay. But yes. Then that means A has issues, but B is okay. That's why we start from discussing the appeal and everything. Okay. Yes, Council. Exactly. Exactly. Okay. No. Under the section 204 of the MCA, subsection 3. Okay. So now, I was giving you the following cases. Okay. Before we take leave, please read the case of Ochepa versus Uganda. Read the case of Magombe Joshua versus Uganda. Those are all applications. Okay, Magombe Joshua and Ochepa, they have a distinctive feature. One supports the position, another one disregards the position. Okay, Magombe Joshua says it is unconstitutional. Then Ochepa says it is constitutional. So read and get the distinction. Okay.
Which of them are the cases?
Okay. Just read this application. It's Magombe Joshua versus. Okay. The Magombe, they had issues because this appeal, the first one, was determined by Her Lady Justice, is it Mugambe? Okay. Then it was referred, this is the reference, which was referred to the full bench to determine the constitutionality of bail pending. Because they were denied bail in the first application, then they referred to the full bench. That's how it turned into a constitutional interpretation. Okay. This reference, because it was a reference to constitutional court. Okay. Now, also read the case of Uganda versus Katoka Jury. This is an appeal by the DPP because your workshop only shows the accused. What if they give you where the DPP appeals? What if they give you the person representing the DPP? Okay, so you read Katoka Jury. It's case number 5. That was an appeal by one of the greatest lawyers in around Kampala, ZOPA. Who is the head criminal? Okay. No, read that case. Okay, it is good. Okay, you read that, you will see the person in there. Okay, read it. It has good arguments on appeal. Okay, then also read the case of Adan versus Republic. Then Patel, Advin Patel versus Uganda. That is number 21. Then your workshop has not covered revision. Okay, but my dear, don't risk. Don't risk. What makes you think that you may miss it in the eye? Eh? Yes, sir. Okay, but for revision, you read the case of Hassan Basaja Balaba versus Kakande. It has what you call an error apparent in the case of record. Okay, it's the second last, I think. Okay, so read those cases at least. Okay, Basaja Balaba versus Kakande. It's a revision. Okay, so tomorrow we are having council for the week. Okay, it's our last preparation for council for the week, but no, they will just choose, yeah. But the mandatory ones, I think, are these. Okay, so let me wish you guys the best. May the good Lord bless you. Assalamu alaikum wa rahmatullahi wa barakatuh.
When it's unrecovered, it's not available newly.
It's not available newly.
I don't know.
No, what you do